Hi, Lee Phillips here. I'm an attorney. I've actually written a number of books on trusts. And the question I keep getting is how to protect your assets with a trust. And my standard answer is, well, you don't. Having said that, let's look at it for a minute. There are lots of different types of trusts. Revocable trusts, irrevocable trusts, revocable, irrevocable. They're children's trusts. You've basically only got two types, revocable and irrevocable. And then we've got a bunch of subsidiary trusts in each one of those categories. The trust you're going to run onto first is called the living revocable trust or the estate planning trust or whatever it is. It's living because you set it up during your lifetime. Now, the lawyer may slip in what we call a testamentary trust. You don't want that one. That does not create the trust until you die. It's written as part of your will. The living revocable trust is independent of your will. You'll have a will, but you'll also have the trust document. And the reason you're doing this is to avoid probate. It does not protect assets. It does avoid probate. Now, you have to put your assets into the trust, the assets that you would have to sign your name for in order to transfer them. They have to be owned by the trust. You manage it, you can buy, you can sell, you can do whatever you want with it. But technically, when you die, these are not your assets. They're owned by the trust. So the trick is the owner of the asset didn't die. The manager, the trustee of the trust, the manager of the asset died. So we simply get a new trustee or a new manager. And that guy has authority as the successor trustee to sell the assets, to do whatever they want with them, and they don't have to go to court. Now, they can't do whatever they want with them because they have to comply with what the written document, what the trust tells them to do. But people want to put the assets into the trust to protect the assets. Isn't going to work. While you're alive, the trust is called a disregarded entity. The courts, the IRS, everybody disregards it. It's you. Therefore, if I sue you, these assets are basically yours. I get a judgment against you. I say, Your Honor, all those assets are over there in the revocable trust. Make him revoke it and give them to me. And the judge will automatically do that. No problem. No big deal. So it doesn't protect assets at all. Now when you die, wham, instantly this trust becomes an irrevocable trust. So the assets over here, it's an irrevocable trust. Your spouse, your kids, whoever they manage these assets. They're not their assets. So if somebody gets sued, they can't get those assets. Until the assets are actually dispersed to the individuals, your kids, whoever, they're not subject to their lawsuits. If I die, my wife takes over this trust. That trust is not hers. She can manage it, she can use it for her benefit, basically any way she wants, but it's not her assets. So if she gets sued, if she goes in the rest home, whatever happens, those assets aren't considered in this deal. So in a sense, I've used the trust to protect assets, but somebody had to die in order to get that one. I can set up an irrevocable trust today. I move assets into it. Now, I can't be the beneficiary. I can't be the trustee. I can't get the benefit of these assets. If I got the benefit, that would be what is called a self-settled trust. And we don't like that. It's not fair that I'm able to put my assets into a trust over here, still get all the benefit out of it, and not have it be subject to my creditors, my lawsuits, my problem. That's not fair. And we've said, yeah, that's not fair. So if I want to put assets in here and make my kids the beneficiaries, I can do that. Now, it's a gift when I put the assets in. There's a gift tax, all this crap. But I can protect the assets from my creditors because I gave them away. They're gone. Bye. Now, there are certain trusts in the United States today, and about 15-ish states have these. They started in Alaska. It was called an Alaska Trust. Alaska said, look, you're building in Des Moines, deed it to a trust that's in Alaska. And Alaska state law says that after X period of time, 5 years, then this asset locks down into the Alaska Trust, and the creditors in Des Moines, your creditors in Des Moines, they can't get to that building anymore. Has to be a cooling off period, seasoning period, but technically the creditors in Des Moines can't get to that building anymore because it's owned by an Alaskan trust. These are called legacy trusts. They're called asset protection trusts, and Nevada and Wyoming and Utah and North Dakota, a bunch of states have them now. We don't know how effective they are because we don't have a uniform asset protection trust act. Lawyers get together and they create these acts which make it uniform state. So in Utah, I can lock one of these babies down. If I publish in the newspapers and stuff, I can lock it down in like 90 days. Lock the assets into there. I can still get a benefit out of them, but they're not subject to my creditors. That's pretty cool. But if I'm in Wisconsin, I don't know if the Wisconsin courts are going to honor that Utah trust. They just may say, screw you, this piece of property's in Wisconsin, we don't care, we're getting it. So that's where we are on these asset protection legacy trusts, Alaska trusts, whatever you want to call them. But the trust, back to the trust that you're going to use, no asset protection. Having said that, maybe I can get asset protection out of it. If I create one trust for him and one trust for her, spouses, then I put assets in her trust. He's the doctor or whatever. He gets sued. They can't come and get her assets if we're in a common law state. Now, community property states, husband and wife are one legal entity. It's harder to separate these. But in most states, there's 8 or 9 community property states, mostly the southwest U.S. If we're in a common law state, he can have a trust, she can have a trust, and those two are independent. The trusts themselves don't give any asset protection. What I've done is I've separated ownership. They can't get to your property if they sue me. They can't get to her property if they sue him. So we've separated ownership. The reason we use the trusts is not asset protection, it's to make it so that when she dies, he doesn't have to probate all the assets, the house he's living in. So we use the trusts not for asset protection, but for convenience. We get the asset protection by separating ownership. So when people say, how do you protect your assets in a trust? I'm not sure that I can tell you that you can do that, because you don't want the types of trusts that can actually do that. You want a simple, living, revocable trust. Avoid probate, pass the assets to my heirs and manage them effectively if I get disabled or can't manage them myself. That's why you use this trust. And 98% of the trusts out there are these living revocable trusts. 0 asset protection. The land trust is revocable. 0 asset protection. If it has the word R in it, revocable. 0 asset protection. So just be aware, lots of different types of trusts, but generally you're not going to get asset protection out of a trust. You're going to use an LLC for your asset protection. That's another story. Now, don't forget to subscribe and say that you love us and all of this sort of stuff. And I do put these out every week or so that I can update people. If you have a suggestion, put it down below. Make sure that you let us know what you're doing and register. In fact, go ahead and get my ebook. It's free. I'll give it to you. We don't spam your email or any of that crap. Get my ebook, How to Use a Trust. This is Lee Phillips talking about how to protect your assets with a trust.